All right. Good morning, everyone. So today what I'm going to be going over is the cancellation of the contracts. And when I say contracts, I mean the listing contract, the purchase contract, and also we've been training on the both the execution and today the cancellation of the buyer representation agreement. So we'll take care of all of those. So what I'm going to be doing is going over the cancellation of the listing agreement. Then leading into the purchase agreement contract, go over what are the contingencies of that contract, which are the excuses for a buyer to cancel, going over the contingency removal forms, both for the buyer and the seller, and the notices to perform for both the buyer and seller, which lead up to that cancellation, the cancellation of the purchase contract, and the allocation of the deposit. Then the cancellation of the buyer representation agreement. So let's get into that. First, I'm going to be showing a part of it's not in the packet here, but a part of the listing contract. So Mike Gutierrez did a really good training this past Wednesday on presenting that contract plus the disclosures to your sellers. I would go back and watch that recording. It's not up yet. It's a pretty big file, so I've been having trouble uploading it, but it'll go up by this weekend. So the listing contract. So we went over how to present it. I've gone over how to fill it out in the past. And now I'm going to point out some of the things that you might want to prepare your seller for as far as what happens when this is canceled. Typically, we have a 6-month period where this is active. And always remember the day that you have this contract signed between you and your seller, it needs to be on the MLS with a picture, at least one of the front on the MLS. That's just a rule. There are fines associated with that. But let's go down to the leading up to the cancellation or the terms of the cancellation. One important part here is the 180 days. Always put that down. So what that means, if you're not aware of that, is that, well, first of all, if you and I would recommend that you do keep track of every person, potential buyer or even a buyer that actually submitted an offer, keep track of all those names. Everybody that went to the open house. If you're doing an open house, I'll always recommend you keep a sign-in sheet with their contact information, either phone number, email, either one or both, because you have a sheet that you're going to have to give your seller of everybody that either saw the property, submitted an offer, whether accepted or not, within that listing period, within the 6-month period. So if your listing were to cancel, and before cancellation, I would kind of bring this up to the brokers or one of your managers and figure out if there's a way to save that. It is a listing. We need those. Those are kind of what'll uh, bring up your numbers. So what I would do is keep that list, but also bring it up to your manager. What could we do to save it? But if it were to cancel that same day, or even if it were to expire, we went up to this period of the cancellation. As soon as it cancels or expired, send that list of all the prospective buyers to your seller. So what that does is that if those people that are on that list buy that property within this time period, that's after it cancels or expires, you may be entitled to a compensation. So that's really important. Keep that the same as that listing period, typically 6 months. So that way you reserve those buyers. That's called a safety clause or a continuation of right to compensation for broker identified prospective buyers. So that way, when it cancels, you have some protection with those buyers. So let me bring up the cancellation of the listing. So a couple of things to take a look at. Oh, that's the buyer representation. Let's see. Cancellation to listing. Okay, so once you're in talks about cancel the listing, just let them know what'll happen. Our listing cancels. So what happens to that compensation? Are we going to get paid? How? And what's going to happen after that cancellation? So what you would want to do, and I would recommend, is on that first section, talk to the seller about those buyers that you brought in, the offers that you presented to that seller, but they rejected. That's why every offer that either you create for a buyer where you're a dual agent, or if some other company brings in an offer and the seller rejects it, you have a record of that. And plus, everybody that came into the open house, you have a list of that. So 1A, what it's talking about, it's saying, let me bring up the little flashlight or spotlight. That's what it is. So if prior to the end of the listing period or any extension, principal enters into a contract to sell, convey, or lease a property. So what this is saying is if before the end of the period, that seller got a buyer, then you would be owed compensation. So what you're asking is, well, uh, why would there be a buyer if I'm canceling the listing? So that would be the case where, let's say you got into pending and the purchase contract is still going, but you happen to be canceling the listing in the middle of escrow. That'd be kind of a weird situation, but yeah, it could happen where the listing is on the MLS, you marked it pending, now you're in escrow. So because you have a listing contract, you have a right to be compensated because now you're in escrow and you're going to close. But what if you're in escrow and you're owed compensation, but the listing is being canceled? Well, this cancellation will make it so that you still get paid from that escrow. Does that make sense? You're just replacing the listing contract commission agreement, compensation agreement, with this compensation agreement now. So now you're retaining your right to get compensated just in case the listing cancels. That's kind of a weird situation, but they put it here because we want to protect you, right? Then, or B, this is the B part. That's the part I was just talking about with that 180 calendar days, where if within 6 months, 180 days after cancellation, somebody in that list you gave that seller, if they buy it, then you'd be owed compensation. So what is that list? Well, anybody you put in here in that blank space. So it could be just a paper list, which would be I put in here list. Just I mean, it could be a Word document. Just title it "Prospective Buyers for this property and the seller." It could be an addendum, which is a generic addendum here in the car forms. So it could be this. There's a lot of addendums. One of these. You could write down C addendum number 1. Then you got this. Oh, this is from another training. Then list out everybody. Or if you have a list somewhere else, you can copy and paste it in here. Even if you paste text in here that doesn't fit, what it'll do is if you e-sign it, it'll create a text overflow addendum, TOA. Basically, it'll automatically add a form and it'll just paste the text that you put in. So this is where that list goes of prospective buyers after you cancel the listing. So don't forget to do that. Because you brought the buyers, right? You listed the property, and what you were doing was bringing in buyers, bringing in offers. So you should be compensated for that, right? Let's go down here. Or buyer agrees to pay broker a certain percentage, regardless of whether it was somebody you brought in. So I don't see that happening very often. That would be a special case. And let's backtrack a little bit. C. So 1C, in the event of a transaction specified A or B above, you bring somebody in or somebody that bought the property or saw the property or went in or submitted an offer. If these people buy the property, you don't have to do anything. Broker has no obligation to represent principal in such transaction. So yeah, I mean it's not your responsibility because you're no longer representing that client. Or three, out-of-pocket expenses. You could do that, reimburse you for any photographs, any staging, any expensive marketing you did. You could ask them to compensate you, reimburse you over here. Or if you just want to get rid of them, principal owes no compensation. That's if you were having an issue with them and you just want nothing to do with it. But for the most part, stick with one. Have that list of reserve buyers. Um, then you'll be protected. The main thing to take away from this form, just keep track of who you were working with, especially the buyers. So it's pretty self-explanatory. Rule of thumb, do number one A or B. Any questions? Zoom in here? No. All right, next one is, okay, now we're working with buyers. So the next one I want to show you, or the next sheet, is part of the purchase contract. So on page 2 of 17 of this contract is where all of the contingencies are. Never mind the 3,003% up here. Don't worry about that. Uh, Part L is where the contingencies are. Those are our big time periods for a buyer. That's when that 17-day, that's where that buyer has to decide, do I want to go through with this transaction or do I want to cancel based on the loan contingency, 17 days, the appraisal, if there is one, uh, the ability to find insurance, the review of the seller documents, that's the transfer disclosure statement, the natural hazard disclosure statement, maybe the lead-based paint, if that applies, all the statutory disclosures that are required by law, which include those three. The buyer can take a look at those. Uh, it's contingent on reviewing the preliminary title report, which a title provides and may cause some red flags that will cause a buyer to cancel or go through. Common interest disclosures, uh, the rules for an HOA, for example, what they can and can't do. The review of leased or liened items. The solar panels are a big one. Bill Hill did a training last month on that about the issues with solar panels, whether or not it can be transferred. So all of these things are things that the buyer will have to check out. And if the buyer just not agreeing with it, or they can't get the loan, they can't get the appraisal, they don't like the physical condition within the first 17 days, the buyer has to either cancel on the 17th day or remove that contingency, and now they're going to go through with it. They're committing to that. So those disclosures are what we're going to talk about. Or sorry, those contingencies and the removals. So the next one is the buyer contingency removal. So we're on day 17. Now the buyer has to decide what they're going to do. So the buyer's obligation is for uh, is signing that contingency removal. So we have the buyer contingency removal here. So the buyer said that by day 17, they were going to either remove that contingency, which would kind of make them go through with it, or cancel. So here, the buyer can remove their contingency. So you have spots to elect whether or not the buyer is going to remove them based on the loan, the appraisal, the investigation, which is kind of split up between different ones. either the entire investigation or only looking at it physically, or all other investigations other than physical, like the looking at what the seller said, looking at the transfer disclosure statement, what all those answers to the questions were, or all of them except maybe looking at the physical or looking at the physical property. They haven't been there yet. Then the insurance, so it just lists them all out, all the ones that I mentioned in that other list, the RPA list, page 2 of 17. So the buyer can either um, do it themselves and say, okay, I said I was going to remove my contingencies on day 17, or all of them right down here on 4. I said I was going to do that, or the buyer can be forced to sign this form by the seller. And that leads into, well, I'll go over this next one first. So the next one on your packet is now in turn the seller contingency removal, which is right here. Now, these are the cancellation rights for the seller. So the buyer contingency removal, everything that you explain to the buyer, you can have all these things investigated. You are going to get pre-approved for your loan. We're going to order the appraisal and just make sure it appraises for value. Those are your cancellation rights. If those things can't be done, then you have a right to cancel. So you're seeing here that the buyer has all these contingencies, but the seller has like 2. So it's a lot harder for the seller to cancel than the buyer. The buyer can just say, I don't like the physical condition. I don't like what showed up in this tremor report. I'm out. The seller, not so easy. The seller basically has one, but kind of 2 parts of that. And that condition is seller removal of seller contingencies, which is the SPRP. So I'll bring it up here really, really quick. So it's not in my zip form. It's not in your packet here, but I'll bring it up. So how do I bring up forms that I don't have? I'll go to Add, go to the car library. Oh, it's already in there. So here it is. So this is the form that grants the seller the protection of having to find something or close on something before they sell this. And they have to close on it. So there's contingent on them finding something or finding something and closing on it. It says here they have 17 days to identify a property, or you can make it longer depending on what that market is. 30 days to find something. Excuse me. Then they can close concurrently. So that's so, excuse me. So that's the seller's removal. Sorry, guys, having a coughing attack here. All right, so those are the contingency removals. So what if, so there's timelines to these contingencies, right? 17 days for all of the buyer stuff. Uh, the SPRP, we saw that there it's 17, or bring it up to 30. So what if that client or that party does not get that thing done in time? And just remember on the buyer contingency removal, those are just the contingencies. There's a bunch of other stuff the buyer has to do. So if let's say the buyer is coming up on day 17, they said they were going to remove their contingency, and doing that would help the seller. If the buyer doesn't do that, then the seller can choose, they don't have to, but they can choose to enforce that timeline. How does the seller force the buyer to remove that? Here's where we get into the notices. So the seller can say, you know what? I accepted a backup offer. It's a lot better. I can't just cancel just like that. Even though I get a better offer and I accepted it, I have to wait until this offer, this escrow cancels. So now in that case, the seller is going to be extra motivated to make sure this buyer, uh, finishes their timelines. So now the seller is going to say, I need to know how I can make this contract cancel so I can accept this backup. So the way you do that is for the seller to give the buyer a notice to buyer to perform. So this one, it's saying that the seller is, aggressively enforcing those timelines. So what's happening here? Uh, so the seller is saying, we're on day 17. You said you were going to do all of this stuff. So what the seller can actually do is submit this and ask the buyer to remove either uh, their investigation and their loan and their appraisal, but not these. So they can pick and choose which ones. But you have to be careful because these can have different timelines. Your contract might have said that the buyer has 17 days to investigate and to get reports and to ask for repairs. But maybe the buyer wrote in their contract that they have 30 days for the loan, for example. So if those contingencies have different time periods, you can't use this if you haven't reached one of the time periods. If you're at day 17 and the investigation contingency is 17 days, but the loan is 30 days, we're not there yet. We can't do it that early. So we couldn't do this, all contingencies. Or we can't submit this notice until we reach at least 2 days prior. The earliest we can be is 2 days before they have to do it. So just keep that in mind because we can't submit it too early. And if we do, it's invalid for the one that's too early. Does that make sense, everybody here on Zoom? That's why it says way down here in bold at the very bottom, right above the seller signature. If you do not remove the specified contingencies, either CR, the contingency removal, or RR, the request for repair, and take that specified contractual action within 2 days, then the seller may cancel. So if the buyer gets this, they have 2 days to do whatever they were asked to do. So the seller could submit this on day 15. If all the contingencies were 17 days, then the seller could do this. Day 15, remove them all. So they have 2 days to comply. So by day 17, this would all have to be straightened out. So the seller can do a notice for a buyer, compel them to or make them uh, remove their contingencies. If the buyer removes them all, we're good. But the buyer now loses their excuses to cancel. So that's why it's important for you as a buyer's agent to follow the timelines, make sure the lender's doing their work, make sure the appraisal is ordered and gets back early enough before day 17. make sure all the inspections are done, and you get all those inspections back in time so that you can do a request for repair. If you ordered a termite inspection, a home inspection, a roof inspection, make sure you get them all and get one request for repair prepared. Maybe you're asking for section one or section two items for the termite, maybe some cosmetic stuff that came from the request for repair. Get them all, do a request for repair, and submit it. Because, so this isn't in your packet here. So going back to the contingency removals, this could have come from, so if you look up here, it says it's part of the purchase agreement. And what that part means is that, well, the buyer and seller agreed that we have 17 days in the purchase agreement, or this could come from a request for repair. The request for repair, how does that play into here? I'll bring it up really quick. So the buyer did what they were supposed to, ordered all of their inspections, the termite inspection, home inspection. Then they created one of these. So we put down, okay, in the home inspection, we want items number 1, 5, 17, and 22. The appraisal items, we're going to just copy and paste it from the appraisal of what the appraiser requires in order for that to be a good appraisal. Then the buyer responds, the seller responds of what they will and will not do. Then what plays into the contingency removal is right here, the seller response. Seller is actually agreed to everything. 1A, seller agrees to all of the buyer requests. But here's the kicker. C, additional conditions. The seller agreement only applies if the buyer removes those contingencies identified on the attached contingency removal. So I'm only going to do these repairs. I'm only agreeing to that if you remove your contingencies, which is fair, right? The seller is doing everything the buyer wants, doing all the repairs, but the buyer in turn has to remove the excuse to cancel. Because now after they signed that removal, if they try to cancel after that, they're in breach of contract. The seller is doing all the repairs. And if the buyer comes back and says, well, you know what? Actually, I'm going to cancel based on the investigation contingency. But they removed it. They don't have it. They can't cancel based on that. So that's why, the seller can agree to everything, but then protect themselves by forcing the buyer to remove that. That way the buyer can't cancel later on based on that. So that's where that comes from, the CR based on the request for repair. Any questions on that? Might be a little complicated. No. Okay. So that was the notice of buyer to perform, the seller enforcing those timelines. So the next one is a pretty similar form, but for the seller. So notice to seller to perform. The same idea. Here the buyer is telling the seller to do a bunch of stuff. So it's mostly contractual actions because the seller only has basically one contingency, right? Here at the very bottom on 2, finding a replacement property or closing on it. But up here, they have a lot more. Like we were talking about earlier, the seller has to deliver information related to lease or lien items. Basically, we're talking about solar here. So the seller has to do that, right? Within 7 days, all those reports. Fully completed lead disclosures. Well, here's the important one, B. That's why you communicate with the listing agent. Hey, we're on day 6, coming up on day 7. Do you have all the statutory disclosures? Over here, you have the TDS, the NHD, the SPQ, the ESD, for example. So all those disclosures that are on our checklist that Mike G went over on Wednesday, some of those are legally required, and these are four of them. So if we're on day seven, actually, if we're on day eight and we haven't gotten those, well, you know what? The seller said they would. You're trying to contact the listing agent and they're not responding. And the buyer is saying, you know what, I'm getting kind of fed up. This seller doesn't seem serious about it. And I already found another property where I might want to submit an offer on, but I want to get rid of this one. So we force the seller to provide those things. But if the seller does perform, then this kind of dies out. So what else does the seller have to do? The lead disclosure, it kind of just points that one out. The fire hardening, the booklets, those are actually included within the Natural Hazard Disclosure Report, the HD. Most companies include those pamphlets and guides, like the earthquake, environmental hazards, like asbestos and everything else. The condo disclosures, the insurance claims that they might have had in the past, the preliminary title report, even things as simple as the disclosure and evidence of authority to act in a representative capacity. Basically, what that means is that if we notice that the seller on the contract is, uh, some company LLC, so we have to know what individuals have the capacity to sign for that corporation. So they have to tell us that. Delivery of an inspection. So if in the purchase contract, the buyer asked for a termite inspection, well, the seller agreed. Well, the seller has to purchase that, get the report, and give it to the buyer. There's no way around it. Even removal of abandoned personal property. And you can read more about that on paragraph 7B2 on the purchase agreement. So they can't just leave their junk there. They agree to remove it. So if the seller does not do any of these within the timeline that they agreed on in the purchase contract, then the buyer can come and say, here, deliver this. Sorry, we deliver it. Complete these contractual actions, or I have the right to cancel. They don't. The buyer doesn't have to cancel. It's just kind of uh, a notice, and the seller has to provide that within 2 days. So down here in bold, way at the bottom, references that 2 days still. So if the seller complies and completes all those contractual actions, or removes their contingencies here on part two, the SPRP, the seller purchase or replacement. If they don't remove that contingency within 2 days, now the buyer may cancel. And let's see. Yeah, just like the buyer notice to perform, it's just a way of enforcing those timelines based on the contract. Any questions on those? I was helping an agent out filling one of these the other day. But otherwise, I don't see them done very often. We're pretty good about following the timelines. And now we get to the final one. Well, second to last, the cancellation of the contract. So now let's say the seller didn't deliver the fully executed supplemental disclosures within 2 days. Now the buyer is happy that they can finally cancel this contract. So now we go to the cancellation of the contract, and the release of deposit. So this one has always been basically two forms packed into one, and I'll show you what that means. The okay, so we're canceling the contract and we're canceling the escrow. So those are two different sections. So in the case I just pointed out that the seller didn't submit Well, you know what? Let's say it's something else, more simple, more common. The buyer got a bunch of reports. The buyer submitted a request for repairs based on the condition of the property that they want repaired, but the buyer saw that the seller denied that, and the seller just or the buyer can't just go through with it. So now the buyer still has their contingency. They still have the right to cancel, so they will. So now on cancellation of the contract, we're canceling the RPA. We're canceling the purchase contract. So now on 1A, the buyer said they want to cancel. And the most common reason is that they're as permitted by the good faith exercise of paragraphs, and we need to put a reason there. So if they're canceling based on the physical condition of the property, it'll be 14B. That's section 14B of the purchase agreement. Or the seller didn't fulfill their obligations and we gave them notice. That's a thing. It's a two-step process to canceling the contract. Somebody has to not do something. Let's say in this case, three. The buyer asks the seller to perform a contractual obligation, and they didn't. So we submitted an NSP, the notice for the seller to perform that obligation. They didn't do it, so that gives the buyer the right to cancel based on that. So the seller didn't provide the reports they said they would. The buyer got impatient. They submitted a notice. 2 days passed. Seller didn't do anything. So the buyer says, I'm walking away. That would be three. Or, which I see it sometimes, not that common, the proposed mutual cancellation. Sure, that's fine. But something happened in that contract, in that escrow, where at least one person wanted to cancel. They just didn't want to both cancel at the same time. I don't see why that would really happen, but they can just both agree, uh, sign here, and that's it. And so it says here, big, bold with asterisk in all caps, sign in this section solely for cancellation of contract. Proceed to the next section for disposition of deposit and the cancellation of escrow. So that's why I said these are kind of two forms in one. Page one, we're canceling the purchase contract, the car form. And down here, we're figuring out what's happening with the deposit. 2B, the release of deposit is not automatic. We have to have this in writing. So here on C, put down the escrow number and the company. Pretty easy. Then when the buyer is filling this out, we're electing what's going to happen with the deposit. The buyer wants their deposit right because they want to close this escrow, cancel it, move on to the next. So make sure you put up C1. Seller authorizes release of buyer's deposit to the seller. So that's the one that your buyer would want. So always check that off. So if you're representing the buyer, what you don't want to do is two. That's saying that the buyer's deposit is being given to the seller. Don't do that by mistake. Be really careful about this part because it determines who's going to keep the deposit. Or they're authorizing the release of only part of it here on three. There might have been some cost or something where the buyer would kind of need to give it to the seller. There's an option here. Or what I've seen happen sometimes, the buyer I mean, way back when I was selling, it happened to me where I had a buyer for a property. They accepted. Like within 2 days, they wanted to cancel. They wouldn't give me they give me some kind of vague reason about the condition, but they wouldn't really point it out. But they just wanted to cancel. They never turned in their deposit. So in that case, it would be C4. There is no deposit in escrow, and yeah, there's nothing to allocate in that. Or D, the partial release and reservation of rights. I mean, repeating the escrow number and the escrow company. Then there's no obligation for anybody to buy or sell. Then they sign. So once you have this all filled out, be really careful with it, with especially C, depending on who you represent. Sign that. The next step is to send it off to the escrow company and the lender, if there is one. They're aware of it. Uh, if there's any dispute within the deposit, the escrow company will reach out because they do need written authorization for what happens to the deposit. And if there's a dispute and maybe the buyer was trying to cancel in bad faith, they breached the contract, then you would go into mediation. Next step, arbitration. So for that, just see the broker. We're going to have to go to CAR and try to figure that out. Any questions on that one? Okay. So the last one, cancellation of buyer representation. So the idea behind this one, it's pretty similar to the cancellation of a listing contract that we saw at the very beginning. So we're giving notice of cancellation of buyer representation. So A, by signing in the applicable box below, the buyer or maybe us, we don't want to work with this buyer anymore for whatever reason, but it might be both uh, that we're no longer going to be their representation, and especially B, if the buyer representation agreement is for non-exclusive representation, the cancellation is effective immediately. So going back to the BRBC, I'll bring it up here really quick. So no matter what, we would have already have had to, if we represented the buyer, we would already have had to have this agreement, which should be exclusive. Always mark down, this is in your packet, but always mark down exclusive. That protects you. They're tied to you during that whole period, the 3 month period max. So if it is exclusive, what happens here is it doesn't immediately cancel. Oh, where's the... So I'll bring it up here. All right, just give me a sec. I'll add it. Oh, here it is. Mm, There we go. So if you did accidentally not check that box off and it's for a non-exclusive buyer representation and broker compensation agreement, it would be canceled immediately. But if you had a exclusive representation right over here, it actually gives you a 30-day window to keep them under you. So they would have to understand that, sure, we canceled, but since it's exclusive, it's going to give us a 30-day window so that they basically can't, well, they can go with another broker, but within that window, they would still owe you compensation if they found a property that fit your criteria with them. So if it was a property within, let's say, Tulare County, and they bought something in Tulare County within 30 days of this exclusive representation cancellation, then they would still owe you compensation. They would have had to have told that new agent about that. Maybe they remember, maybe they don't. But that would still be the case where we could basically see whether or not they submitted an offer and closed, in which case they would represent, or they would have to give us compensation. But once the cancellation becomes effective, the broker will not be buyer's agent. We have no fiduciary obligation to them after it's canceled. And the compensation, if they still owe us compensation even after the cancellation is executed, it'll be based on whatever is on the BRBC or the PSRA, the 2.5 or 3%, whatever we put on there. We check off this box. Then we put in here 30 calendar days. And then we just keep track of whatever properties we showed them. And then we would be owed compensation afterward. I mean, are you going to have expenses with the buyer when showing it? I mean, maybe if you kept track of gas, that could be something, and you did want to get that reimbursed, you could. Or maybe you're not really getting everything. You don't want to put the buyer in the spot where they have to pay you the full compensation that you're owed because of an identified property. Maybe just get a referral fee, brokerage or receiver referral fee. Uh, Partially, maybe just say, well, you know what? I showed that buyer that property, and it's a property identified uh, within our representation period. But if there's a back and forth, maybe you just let it go and say, you know what? I'm not even going to ask for the full 3%, maybe a 25% of what you receive, which is going to be a lot less. Or you just want to get rid of them and just say, you know what? You're not gonna owe me anything even afterward. So no compensation. So, overall, we don't like these forms, but we have to be prepared, especially with the continued period that's after the cancellation of either contract, whether it's the listing contract or the buyer representation. Just keep track of those identified properties. And if they do buy something that's on that list, or the seller sells that property to somebody you showed the buyer to, or showed that property to some buyer you have reserved, then you'll be protected. Any questions? No. Okay, that's all I have. Thanks, guys, for your time, and you have a great weekend.